I was asking her how long she gives for the board hire. Do you have an opinion? I said
Do I need to bring
45
my,
minutes.
are they gonna bring my inmate tomorrow after all, or no?
Yes, yes, they are.
I still have to be here.
Yes,
I have to go rent the suit for tomorrow?
yes.
Okay, I'll be here in the morning.
All right.
Thank you, Ron.
He said 45 minutes aside is fine. If he's going a tiny bit long, I'm not going to object.
Okay, well, it'll be 20 minutes, 20 minutes, and then 20 minutes, 20 minutes.
Okay, how do you do this? I should have asked you that.
General, specific.
Do you want us to make challenges for cause at the time we're doing specific? Okay.
Just keep your notes, and usually what I do, if there's something that you all can agree on, then I usually go with that agreement. If there's something you can't agree on, just let me know.
Yes, ma'am.
Okay. Can you make sure that it's off, please? The sound. Mr. Juarez? We're gonna bring you back. Who's your attorney?
Yes, ma'am.
Who's your attorney?
Carl, Bexar, something like that. I'm sorry.
All right, it's Carl Basil. We're gonna bring you back tomorrow. Ms. Ferguson, Mr. Juarez is back tomorrow. Okay. All right, Mr. Robinick, you said you wanted to place something on the record?
Please, John,
All right, you can go ahead.
let my client come up.
Yes. But don't just stand right there, not past the glass.
Mr. Contreras, I'm putting this on record because I'm concerned for it. But, right now, you're facing an aggravated weapon charge, which carries a deadly weapon. That's pushed with 5 years in prison to 90 hours. The big thing is that you have a previous penalty, and that previous penalty means that you have a minimum for conviction on 15 years in prison, 99 years in 60. If you're convicted of an aggravated offense, you have to do half your time. You just call it 3G, something different now. So what you're really doing is you're convicted and there's 4 counts. You're looking at a minimum of 15. The reason I'm telling you this is that the state's original offer was 8 years. Now they made you an offer of count of 9. And that count of 9 would be judge giving anywhere between 5 and
All right, and Ms. Ferguson, if you go to breakout room number 2 and let Mr. Brianna know that he needs to be here tomorrow morning at 9 a.m. for his client. And they are not to leave the breakout rooms during our jury selection. All right, so Mr. Cox, we'll have you come back and see where this goes. We'll have you come back tomorrow at 9 a.m. Thank you. And he should have received a reset form. All right, the court is going to call 2019 CR 8169, State of Texas versus Marco Anthony Contreras. Do I have parties announced for the record for the state? For the defense?
Eddie Robinick.
And are you Mr. Contreras?
Yes, Your Honor.
All right, state, are you ready to proceed?
Yes, Judge.
Defense?
We are, Your Honor.
All right, Mr. Contreras, we're going to have the jurors brought in. Yes. All right, thank you. Who is the person on Jose Ramos? Is that criminal child abuse? All right, could you go to breakout room number 2? I think Norma has a computer. And could you let Mr. Brianna know that he and his client are not to leave that breakout room? Because it's an inmate, and I don't want the jurors to see that. Thank you.
It's tradition. Understand what-
All right.
All right, everyone, please be seated. All right, could I have the state and the defense please approach? Brenda? Yes, please. Yeah, I'm going to move that jurors 15, 42, 67, 70, and 90. Y'all will proceed with them being present, but we want to discover where they are. We have them here.
The state is good with proceeding.
Let's go forward.
Oh, thank you.
Can you tell us the numbers one more time?
It's 15. 15, 42, 67, and 70.
Judge, can I just a moment tell my client that?
Yes.
Thank you.
All right, thank you. All right, ladies and gentlemen of the jury, Thank you so much for your patience outside. I know when people are called to appear, they want to appear and be in court at the time that they've told to appear. But in this court and other courtrooms, what ends up happening is we do have other dockets that we're handling. And with that being said, I want you all to know that you may see people who will be coming through these doors to speak with me, and it's on matters that are not related to this case. The temperature in the 187 District Court, I have no control over it whatsoever. I've talked to maintenance about it, but nothing has happened. You may see the lights flicker. I've talked to maintenance about that, so nothing has happened. We're going to start what's called jury selection. I'm Stephanie Boyd. I'm the judge of the 187 District Court. I want you all to remember that you're in the 187 District Court, 4th floor. The reason why I tell you that is because we cannot start any of jury selection unless you're all here. And sometimes when we take breaks, people forget that they're in the 187 District Court, 4th floor. At one point in time, we actually had someone we were waiting for, and they were down the hallway about to start jury selection in another court. So if you ever get lost, which courtroom are you in? Awesome. So the person to my right is Brenna DeMoss. She is the court reporter. She takes down everything that's being said. Right now, she's taking down everything that I'm saying. She is an excellent court reporter. She can take down what people are saying, 3 people at a time. But just one moment. But let's not make her life more difficult. Let's each speak 1 person at a time. All right. So what you're holding in front of you are very expensive cards. They cost a lot of money to make and a lot of time. So everyone, if you could raise your card for me, please. Awesome, that's great. So when anybody asks you a question and you want to respond to it, raise your card, because then people will be able to recognize your number, and Brenna will be able to take everything down. So remember, if there's something you want to say or you want to respond to something, just raise your card. Now, I've introduced myself to you, and I want the state and the defense to introduce themselves to you along with the person who's on trial today. State.
Good afternoon. My name is Mark Sanders.
My name is Ryan Brewer.
Yes.
My name is Eddie Broadback.
My name is Marco Contreras.
All right. So of those people who introduced themselves to you, is there anyone here who knows or recognizes any of those persons? Okay, I'm going to take that as a no. Now, other than meeting downstairs, do any of you on the jury know each other? Ah, okay. So we have 24, 29, 35, 40, 47, 50, and numbers 6 and 58. All right, number 6, who do you know on the jury?
Well, I know who she is. That's number 47.
Okay. And number 24, who do you know? And 29, who do you know?
32 and 31.
All right, 32 and 31 did not raise their card. 32 and 31, do you know juror number 29? Okay. All right, other than just meeting today, juror number 40, you raised your card. Who do you know? I'm sorry, I'm gonna have to ask you to send.
He said just.
I know 50.
Number 50. Okay, all right, thank you very much. And here's the other rule. Oh, 58, who do you know?
I work with number 6. Yeah, sorry. Forgot about
Okay. All right, well, I hope this will not result in a discussion at work later on. All right, so this is one of the other rules. Brenda has to take down everything that everyone's saying. I have a microphone, state, defense, they all have microphones, but as you can tell, you don't have a microphone. So to make it easier for her to hear and for me to hear, anyone who is not in the jury box and not on this front row, when you speak, I'll need you to stand. Can everyone do that for me? Awesome, thank you. All right, so the charge in this case is aggravated robbery. I want you all to just think about that for a moment. The range of punishment for that offense is anywhere from 5 to 99 years or life in prison. Think about that for a moment. Or the range of punishment may be 15 to 99 years or life. Those are different ranges of punishment that we have here in Texas. And a lot of people will say, wow, that's a big range, right? And one of the questions that is always asked of jurors, and I'm going to ask it of you, is someone who's charged with aggravated robbery, can you consider that entire range? Now, what I mean by that is you don't have to agree right now that if someone's found guilty of aggravated robbery, oh yeah, I'm going to give them life. Oh yeah, I'm going to give them 99 years. According to the law, I've given you the range of punishment. So it's just, are you able to consider that? Not that you would necessarily give it, but that you would consider it. Does everyone understand? Is there anyone who does not understand? All right. Now, when people are brought to a felony court and they're brought for jury trial or held over for jury trial, how they get here is through what's called an indictment. An indictment is not an evidence of guilt. It's just a means by which a person is brought to court. How many people have had a traffic ticket? Remember the card. See, these questions I'm getting you to get used to raising the card. All right, so I've had one traffic ticket in my life. And yes, it's true. And when I got the traffic ticket, that was back in the day where they gave you a piece of paper. Now I guess it's electronic or whatever they do. But if an officer pulls you over, and let's say they say you're speeding or you ran a stop sign or you didn't abide by the yield sign, and they give you a ticket, that's them telling you, this is what you're charged with. And when you accept that ticket and appear in court, that ticket is not an evidence of your guilt. This is what somebody is saying. You didn't stop at the stop sign or you were speeding. And then you get to go to court. And then what happens is whomever's charging you, whatever municipality or wherever it is that says you were speeding, they have to prove that you were speeding. An indictment is exactly like that. An indictment is just telling a person, this is what you're charged with. This is where you have to appear. Does everyone understand? Yes. Does everyone understand that just being indicted is not an evidence of guilt whatsoever? Does everyone understand that?
Yes.
Right. Now, there are certain rules that we have also in regards to rights of defendants or people who are accused. How many people have heard of the right to remain silent? Where are my Matlock people, my Maddox, Barnaby Jones? I always age myself when I say that. Well, everyone has a right not to testify against themselves. Does everybody understand that?
Yes.
Now, a lot of times people will say like, I really would have liked to know what this person would have said or somebody, the accused person would have said. Well, it's okay to feel that way, but you cannot hold it against a person if they decide not to testify. And you cannot use that whatsoever at all in your deliberation. Does everyone understand?
Yes.
Yes.
Is there anyone here who's like, yeah, I know you're saying that, but I'm not going to do it. I'm going to want to hear from anybody who's accused of an offense testify. Is there anyone who feels that way? The other thing that we have in this, yes.
Number 27 raised his card, Your Honor.
Number 27, did you raise your card?
I did.
All right, thank you. The other thing we have in the United States is something called, you are presumed to be innocent unless and until somebody proves that you're guilty. Does everyone understand that?
Yes.
Does anyone have an issue with presuming someone innocent unless and until they are proven guilty beyond a reasonable doubt. Anyone have an issue with that? So does everyone understand that as Mr. Contreras sits here, he's presumed to be innocent? Does everyone understand that?
Yes.
Is there anyone here who can't follow that? Now, the burden of proof in the United States and Texas is proof beyond a reasonable doubt. When I went to law school, we had to memorize the definition of proof beyond a reasonable doubt. You had to know it backwards and forward. Dream about it. Make sure you knew it. Make sure you knew where every comma, period, semicolon was in that definition. I graduated from law school. I tried my first case. And after I tried that first case, they decided that there would be no more definitions for proof beyond a reasonable doubt. So I still know the definition, but there is no definition for proof beyond a reasonable doubt. So a lot of attorneys will tell you what it is not. And I've been a defense attorney, I've been a prosecutor, and I would always tell people what it was not so you would understand the burden. So on the civil side, you have a preponderance of the evidence. You also have a burden that's called clear and convincing evidence. Clear and convincing is the burden that's used to terminate someone's parental rights. Proof beyond a reasonable doubt is a higher burden than clear and convincing evidence. It's a higher burden than preponderance of the evidence. It's a higher burden than probable cause. It's the highest burden on the criminal side. Does everyone understand?
Yes.
Now, the persons who must prove that someone committed an offense must prove it, each and every element, beyond a reasonable doubt. And that burden rests with the state. That burden never switches to the defense. Does everyone understand?
Yes.
So does everyone understand that the defense does not have to prove anything? Is there anyone here who disagrees with that and thinks that the defense should have to prove their innocence? Now, in Texas, there are two phases to a jury trial. The first phase to a jury trial is what's called, people say it's the innocence phase, but really what it is, the first phase is guilty, not guilty. Evidence is presented, a jury determines whether someone's guilty or not guilty. Then once that happened, there's a second phase. If someone is found not guilty, then that's the end. If they are found guilty, then the second phase is called the punishment phase. And that's where a jury or a judge will determine whether or not the punishment is probation, maybe, whether the punishment is time. Does everyone understand?
Yes.
Now, every person who's accused of a crime in criminal court has to make a decision on who they will ask or wish to have decide their punishment if they are found guilty. The fact that someone is making a decision on who is to decide punishment is in no way an evidence of guilt. It's the law that they must make a decision on who would do punishment if they were found guilty. Does everyone understand?
Yes.
Okay. In this case, Mr. Contreras has decided if he were to be found guilty, then the jury would issue punishment. Is there anyone here who feels, and I don't want to say feels, is there anyone here who has some type of reason why they would not be able to render punishment in any case? Well, wait a minute, let it marinate for a minute. Don't raise the card immediately. Now, I understand that when people get selected or called up for jury duty, you're hoping, sometimes people are like, oh, please just let it be a fender bender, or please let it be, something else, right? Sometimes people don't want to come to criminal court. But in the United States, we have a justice system. And the only way we can have jury trials if we have jurors. So when I ask these questions, I need you to look deep inside yourself and be honest with yourself, honest with the court, honest with everyone here, because the state wants a fair trial and the defense wants a fair trial. So when I say you can't decide punishment, is this going to be damaging to your psyche to decide punishment? Or is there some other reason why you can't decide punishment in the case? So with that being said, does anyone fall in that category? All right, juror number 21. Juror number 46. Now, the state is going to talk to you about the one witness rule. This is the one witness rule. And in all of these examples I'm giving you, they're all hypotheticals. None of it is about this case. The state can't talk to you about this case during selection. The defense can't talk to you about this case during selection. You will only learn about this case and potential facts in this case once you're on the jury. So I want you to remember that all of these scenarios that the state is giving you, that I'm giving you, that the defense is giving you, it is completely hypotheticals. So here's the one witness rule case. And I've had many people describe it, but this is the best way to describe it. You are walking down the street. You're by yourself. There's no one else with you. Someone takes your pen, and I'm just using it as an example. And so you want to charge them for taking your pen. Does everyone follow my example so far? The only person who's there is you and the person who took your pen. There are no witnesses. It's just you. And you say, I want to come to court. I want this heard. I want to go to jury trial. So jury trial happens. You are called to testify. And you say, Stephanie Boyd took my pen. And you tell everything that happened. It was a cold, dark, rainy night. She came up to me. She took my pen without my permission. That is the only evidence that's presented at the trial. Now, as a jury, you hear that evidence. You believe this witness who's testified. You believe that the pen was taken. You believe that Stephanie Boyd took the pen. You don't have any question about their credibility. That one witness has proven every element that the state must prove beyond a reasonable doubt. Is there anyone here who, if there's just one witness, will say, yes, I believe everything that witness said. Yes, that witness proves the state's case, but I'm still going to say not guilty. Is there anyone who feels that way? All right, number 14. All right, in this question, number 13, thank you. All right, here's the next question that I have to ask. Now, mind you, I love when people can speak more than one language. I took French in high school, college. Everyone looks at me because they know I'm originally from Louisiana. So that's the language that I took. Of course, if you're not around people who speak it a lot, you tend to lose it. Well, is there anyone here whose first language is not English and you're not able to understand the English language as well as you think you should to be on this case? Number 26. All right, the other question I have is there anyone who has a time constraint? And by time constraint, I mean travel arrangements. You have non-refundable tickets. You can't substitute me in as the traveler. Is there any, thank you, I see you got that. Is there anyone who has any time restrictions? And I understand that some people have children that maybe you have to pick up from school. We can work around that. But is there anything else? Is there anyone who has maybe a wedding that you planned and you actually want to go through with it? Anything like that? Okay. All right. Number 9, what is your issue?
I'll be out of the country starting May the 8th through May the 16th. I'll be in Canada.
All right. I know the anthem of Canada because I love hockey. Number 22. Okay, you need to stand, everyone on the next row. So where are you going?
Mexico.
All right. Number 14.
I'll be out of state Kentucky from May the 10th.
All right, thank you. I know the Kentucky school song. Number 12.
I'll be in Georgia from the 12th through the 16th of May.
All right, thank you. Number 17.
I'll be in the Smoky Mountains from May 26th to May 20th.
All right, there's a lot of traveling happening. All right, number 26.
I'm out for May 3rd to May 8th. Denver,
I'm sorry, where are you going?
Denver,
Okay,
May 3rd to May 7th.
all right, and 21.
New York from the 25th to 30th.
All right, is there anyone traveling May 1st? See how I eliminate people? All right. Number 46.
Actually, I will be out of town this weekend and then again, May 5th or May 8th.
Where are you headed?
I'll be in Austin this weekend and then Houston the following week.
Okay, Austin. Are you 52 or 25 year side?
Sorry, 52.
All right, if you could stand, please.
I will be in Pennsylvania May 5th through the 8th.
All right, thank you. Anyone else? 23.
I'm not traveling, but I actually have a letter from my mom's doctor. She's on the transplant list. I'm her primary caretaker. So I don't know if that's an exception.
Okay. All right, thank you for letting us know. And we're gonna say goodbyes to her.
Thank you.
So let me see. All right, I'm sorry, number 2 and number 1. Number 1,
Again, not traveling, but I'm a pediatrician in the hospital. I also do sedation cases. I have cases scheduled for tomorrow and Thursday. It's kind of difficult to get coverage right now.
all right, number 2,
I'm starting a new job on the Tuesday the 3rd.
what are you doing at your new job?
It's in Kerrville, Texas. It's not out of state, but I mean, but it is a new job and it's starting a job in Auburn Park in Kerrville, Texas.
All right, and what date does it start?
On the Tuesday the 3rd.
All right, thank you. And number 13?
And I realize that my job does not disqualify my participation in this event, but I just drive the truck for a living. I got my boss's best intentions at heart, you know. I just thought
No, I appreciate it, and I appreciate your driving. You drive a 16-wheeler?
a semi, I'm trying to stay locally in Texas, but they've been running me from Wisconsin to Washington State, Idaho, Kansas, Missouri, like that. So wherever the buck is, I chase it.
Okay, well, I tell you what, I will apologize to all the drivers who get in your lane and then hit their brakes. Okay. And many of my family members are truck drivers, so I understand. All right, so before I turn it over to the state and the defense, I'm going to tell you all a true story. I have this friend who works in Austin, and she and I went to law school together. And we didn't get a chance to spend much time because I practiced criminal law, she practiced civil. And so she was never in trial. And she gets called up for jury duty. And she says, Stephanie, I would love for us to have lunch. We haven't seen each other forever. I'm like, okay, yeah, let's do that. So we have lunch. It's like we've been talking to each other for years, didn't have any separation. And I said, how is jury selection going? She's like, it's going well. And I'm like, what does that mean, it's going well? And she says, oh, I'm not going to get selected. I have the rest of the day over. I'm like, how do you know you're not going to get selected? She says, because it's like when we were in law school, she's like, I'm at the back, I'm staying quiet, I'm not saying anything. And I started laughing at her and she's like, what's so funny? I said, you're so going to be on that jury. And she's like, why? I said, for some reason, in criminal cases, the people who don't say anything end up being on the jury trial. So other than raising your card saying, please select me, being quiet is the easiest way to be selected on the jury. So I say that story, which is true, to encourage people to talk because the state and the defense really want to talk to you and get your ideas on certain things. But remember, when they speak to you, it's not about this specific case. It's a hypothetical, okay? All right, with that being said, I'm going to turn it over to the state, and if anyone ever needs a break, just raise your card and let me know. All right, state, you'll have 20 minutes.
It's juror number 3 is raising.
Yes, juror number 3.
It's something private that yesterday on Zoom, they had said that you would ask, and it wasn't a time constraint or anything, it's something else. But because of HIPAA, I don't want to mention it out loud, so I don't know when would be.
No, we'll take that up afterwards,
Okay.
and we'll have them call you up, okay?
Okay.
All right, thank you. So no one will address that issue with you in public. We'll just call you up afterwards.
Okay, thank you.
You're welcome. All right, state.
Thanks, sir. Good afternoon, everyone. Need a little bit more. Good afternoon. As the judge said, this board hour is also called jury selection. This is our chance to get to talk to you. To try to find out how you feel about the law and certain issues that we think may come up. Sorry in advance, Brenda, I'm gonna talk a little fast, but if I say anything you don't understand, let me know, raise your hand. It happens all the time. So what we're trying to find out is if you can be fair and unbiased in this particular case. The example that I give is that when I was a misdemeanor prosecutor, I was working late one day, I go out to my car and it was broken into. When I broke in the window and taken some things. And I remember back then I used to prosecute burglary vehicles cases. And every time I got one, I would think to myself, could this be the person who broke into my car? And I always said that if I got called for jury duty on a burglary case or a theft case, I couldn't be fair and impartial because I'd be like, this is probably the person based on nothing other than my own personal feelings. And so the question that I'm asking today that Eddie on Mr. Broderick will ask, we're just trying to see how you feel about the law and just to make sure that you would be right for this particular case. And that's why the judge asked if you know anyone, because obviously if you know someone, it could be fair or you may be biased. So for example, let's talk about a possession of marijuana case. Does anyone know who this person is? Who is it? What about that guy? Okay. Willie Nelson. And then these guys. Yes. Seth Rogen, James Franco. So let's say that they got called in for jury duty on a possession of marijuana case. And they were told they have to follow the law. Do you think that they would be able to be fair and impartial in a possession of marijuana case? Probably not, right? They have a strong bias. I mean, everyone laughed, everyone knows exactly. Like that's probably the first thing that comes to mind when you see them. And so if you're chosen for this jury at the end, you're going to be asked to take an oath to render a verdict based on the facts and the evidence that's presented. So we're here for an aggravated robbery case. But before I get into aggravated robbery, I'm going to go over the law and what we have to prove. But before I can talk about aggravated robbery, I have to talk about theft because it's within. You can't commit an aggravated robbery without committing theft. When you hear the word theft, what do you think of? Juror number 4. Stealing something, yeah. Anyone else have a different answer?
It's something that quite possibly I work very hard to buy, own, have a right to position to that.
Yeah. And so there's gonna be times that I'm gonna quote the law for you. If you're chosen on the jury, the judge will give you the law at the end. Sometimes there's definitions, I'll include those. If there is no definition, and if you're chosen for the jury, if there's no definition given to you, that means there is no legal definition, you use the ordinary meaning. I think I have a slide that says that later. But a person commits an offense if he unlawfully appropriates property with intent to deprive the owner of property. And so one word in there, appropriate, has a legal definition. It means to bring about a transfer or purported transfer of title to another, I should say another, possessory interest in property, whether to the act or another. That one I'm not going to focus on. This other one, B, to acquire or exercise control over property other than real property. That's what most people think of when you think of that, right? Someone taking someone else's property. Appropriation is unlawful if it is without the owner's effective consent. So if I were to take, this might that belongs to the room. And he doesn't give you consent, is that a theft? Now, what if you were saying, oh, you can borrow? Pretty simple, right? Plain English, it's taking something that doesn't belong to it. You don't have the person's permission to take it, and take it. So one question I have for you, and I'm gonna ask everyone to answer, I'm gonna ask you to raise your card. The value of the property taken affects how strongly I feel about the offense. And by that I mean, let's say it's a stick of gum stolen from a corner store versus a car that's stolen. And so if the value of the property affects how you feel about the offense, where you're like, oh, no, it's not that big of a deal, then you would fall into that first category, strongly agree, and so on. So either one, strongly agree, two, slightly agree, three, slightly disagree, or four, strongly. Does the question make sense to everyone? Yes. Okay. So the value of the property taken affects how strongly I feel about the offense. Hold your card up if you strongly agree with that. So we have your number, and when I call your number, you can put down your card. Your number is 2, your number 8, 4, 9, 12, 16, 17, 19, 21, 25, 26, 13, 29, 30, 31, 32, 33, 35, 36, 37, 39, 40, 41, 44, 47, 52, 53, 50, 56, 57, 59, 60, 61, 62, 63, 66, 69, 71, 72, 73. And who slightly agrees with that statement? You can raise your card. 3, 5, 6, 11, 20, 22, 23, 24, 28, 34, 43, 46, 48, 49, 51, 55, 58, 64, 65, and 75. Who slightly disagrees with that statement? 1, 7, 10, 27, 38, and 45, and who strongly disagrees? 14, 18, 54, and 68. Thanks a lot. So now that we talked about that, what is a robbery? Person commits an offense if in the course of committing a theft, as defined in chapter 31, and that was the legal definition I gave you, and with intent to obtain or maintain control of the property, he intentionally, knowingly, or recklessly causes bodily injury to another, or intentionally, knowingly threatens or places another in fear of imminent bodily injury. So when you think of a robbery, can someone give me an example of what comes to mind? Your number, what?
So I just picture like seeing some robberies. So people going in with guns or something with the book or running out with the possession.
And so in that situation, what is the property that they're trying to get?
Well, okay, so the bank robbery would be money.
And then how are they placing it here?
With weapons.
Can everyone hear that? And does that make sense? She said, classic example of a bank robbery, someone goes in with a gun, the property that they're trying to steal is money, and then the way that they're placing them in fear is with a weapon, placing them in fear that they're gonna shoot them. So that first part, in the course of committing theft, that has a legal definition. So in the course of committing theft means conduct that occurs in an attempt to commit during the commission or in an immediate flight after the attempt or commission of theft. A lot of words, but it's saying that while someone is committing theft, let's say juror number 8, juror number 6, I try to commit theft and I take your hat and you take it back and I punch you. Is that a robbery?
It's an attempt to robbery. I'm taking it back.
Well, and that's a good one too. So, okay. And so another point, I don't have a slide for this, but even if the person doesn't get away with the property, even if you punch me and knock me out, I still committed the theft. Okay, does that make sense, everyone? Does anyone have a problem with that? And sort of going further than that, if I'm running away and he tries to stop me, so I take the property, or even if I throw the property down and he's like, no, you're not gonna wait, and I punch him then, that's still that. That's in the immediate fight after. Does that make sense to everyone?
Yes.
Does anyone have a problem with that being?
I just have a question.
Yes, sir.
I'm a little confused.
Excuse me.
Oh, sorry. Sorry.
I'm a little confused when you said that if they did not take the property, it's still theft. So why is that?
Because the theft occurs when you appropriate your property, so when you take your property and you have the intent to deprive it.
Okay, what if you walked in and you were gonna try to grab it, and then you didn't grab it, and you left? That's still theft?
And so there's differences where it would depend on how we prove that the person had the intent to deprive instead of they were just grabbing the property. And so that's a burden that we have to get across to y'all that they actually have the intent.
So intent is.
Yes, and I'll go over intent later, but it's in the mind of the defendant, and so I'll talk about the ways how can we prove intent when we're not inside the mind of the defendant, and that will come up later. Did anyone else have any other questions on that? So the next part I want to talk about is intentionally or knowingly or recklessly causes bodily injury to another. This is same example. If I punch you, am I causing bodily injury? And so the second way is by threat. So intentionally or knowingly threaten or places another in fear of imminent bodily injury. So let's say I grab your hat, you say give it back, I say I have a gun. Does that fall into that second definition? Right, I'm placing them in fear. And I have the word "or" capitalized because it's either threatened. So from my perspective, if I'm threatening juror number 6, or if I actually place them in fear. Does that make sense, everyone? So he doesn't actually have to perceive the threat, even if he's like, I'm not scared of them, I can take them. If I'm still says I have a gun and I'm threatening him, it's a robbery. Is that clear, everyone?
Yes.
Next question for everyone. Robberies where there's only the threat of injury are not as important as robberies where there is an actual injury. And we're gonna go strongly agree, slightly disagree, and strongly disagree. So strongly agree, you fall under number 1 to be the raging cause. So threat only. So if I don't actually punch him, I just threaten. Who strongly agrees? Juror number 9 and 4. That's the same. That you don't think that is as important. 9, 24, 25. Does the question make sense, everyone?
No.
No. Okay. So remember I gave 2 examples. I said I can either take his hat and he tries to take it back, and I say, hey, I got a gun. That would be a threat, a robbery like that. Sure. Or I take his hat and try to take it back and I punch him. And that's the first definition where I'm actually committing an injury to him. And so I'm asking, are those equally important, or do you feel like that threat one isn't as important as where I actually attack him or cause him to retain?
So if it can be important, you will strongly agree.
If you think that it's not as important, you could, yeah. Okay, so who falls under number 1? One more time. 9, 24, 26, 30. Who falls under number 2? 8, 56, 58, 66, 73, and 75. Number 3, 5, 4, 14, 19, 20, 22, 31, 35, 36, 40, 47, 51, 52, 55, 69, 72. Oh, right, number 4, who falls into that category? And just so we're all on the same page, 4 says that they're just as important threat and actual causing an injury. So 1, 2, 3, 6, 7, 10, 11, 12, 13, 16, 17, 18, 22. Okay, I was like, 22. So you're 40. Okay. 23, 25, 27, 28, 29, 32, 33, 34, 37, 38, 39, 43, 44, 45, 46, 41, 48, 50, 53, 54, 57, 59, 60, 61, 62, 63, 64, 65, 68, and 74.
4 minutes.
How much?
4.
Left?
4 minutes.
So what makes a robbery aggravated? So it's a robbery. But someone use our exhibit to deadly weapon. Does that make sense? So that's not an example.
He has to pull it out though for it to be accurate.
Well, I'm not gonna, horrible out like that. Use our exhibit. Let me, oh yeah, I'll do it now. Use our exhibit. So showing a gun, if I just say I have a gun, you never say gun. If I do like this, and be like, I have a gun, you're not doing anything. Who agrees that that would be using our exhibit? Does anyone not think that that's using our exhibit?
Yeah.
Yeah.
Sir, so we're talking about using or exhibiting a deadly weapon. And so just having it on my person, that's not necessarily using or exhibiting. But if I pull it out and I'm saying, if I'm holding it at my side, I'm like saying, if you come near me, or I'm using it in a threatening manner, whether it's a gun or a knife, I would have to do that in order to be using or exhibiting a deadly weapon.
Flash.
It's
Flash.
yeah, if I flash it, yeah.
Is it the same as saying I have?
I can't see him.
Sorry, can you stand up, sir?
I'm sorry.
Did you say that, if you didn't make the comparison that he had said I have it? You said, are those the same? Did you say that?
Yes, yeah,
Okay.
so if I don't actually,
So your question was? Yes. Not the same.
no, I think I just asked if that makes sense to everyone.
Oh, I'm sorry.
All right. Yes, sir.
Maybe I shouldn't hear right. Okay, so if aggravated, if you say you have a weapon, even though you don't show it?
No, no.
It's not, okay,
I have to use or exhibit.
okay, thank you.
So deadly weapons, a firearm or anything that in a manner of its use or intended use is capable of causing serious bodily injury. You'll get the legal definition for serious bodily injury. It's selected on the jury, so I'm gonna read that one. Deadly weapons, not guns, knives, swords, bats. Does everyone agree that those are all deadly weapons?
Yes.
And depending on how they're used. Use or exhibit, shooting a gun at someone, pointing a gun at someone, holding a knife at someone, swinging a bat at someone. Does everyone agree that those are all using or exhibiting?
Yes.
For statutory terms are not defined, you just use ordinary meaning. Elements of the offense, if you're chosen on the jury, there's some language in the chart that says elements of the offense. Some juries get confused by it. It's just how we break down the law. So I gave you the legal definition. We state elements because we break it down just to make sure that we get everything that we need to prove the law, but it's just the law broken down. So for theft, you have to prove honor by a certain date and verify the defendant unlawfully appropriated property with intent to deprive the owner. Robbery, honor by a certain date and verify in Texas, defendant in the course of committing a theft with intent to obtain and maintain control of the property, intentionally or knowingly threatens or places another in fear of permanent bodily injury. And then there's that other definition of actually causing bodily injury. And then aggravated robbery, honor by a certain date and verify in Texas, defendant commits a robbery and uses or exhibits a deadly weapon. Mental state. Let me get through that. So how do we prove someone's mental state? So in the example I gave, I said, I'm gonna take your hat, but people don't always announce what they're gonna do. But we can prove it by the circumstances. You don't have to prove why the person did it, you just have to prove those elements. So if you have a question about, oh, anything that's not one of those elements, I don't want to say it doesn't matter, but it's not a burden of ours. You don't have to prove why they did it.
All right. You'll have your 20 minutes with specific.
Okay.
Okay.
Good afternoon. Three things. First of all, thank you on behalf of Mr. Contreras and myself for being here. I know it's frustrating and annoying. I've seen it. My wife's done it. And I'll just tell you right now, I know it's difficult. Thank you. Second thing is, I tend to be pretty straight to the point. I try to make my points and get out. So I do that to save your time, and I'm going to do that before God. My request to you is that if you end up on the jury, that you give me the same respect, which is if there's been 20 minutes and something that's been 5, try to pay your best to pay attention to my 5 minutes. I'll respect your time, and actually do the same. Third of all, we're all rusty. 2.5 years ago, this is what we did every day. Because of COVID, like, we can't remember how to say things, or do things. I couldn't remember some things about jury selection. My questions might be bad. I might try to take your hat, and then we might get.
As long as you don't punch me.
Yes, sir. So what I'm just saying is, bear with us, okay? If I don't make sense, tell me. Eddie, don't make sense. Those of you sitting over here, just with all respect, you probably, like almost certainly, are not going to end up in this jury. So I don't want you to take a nap, but I'm going to be focused on the people over here. Fair enough. Okay.
Why is
Why can't you take a nap?
No.
So the judge brings in a whole bunch of cases. Some like are child sex assaults. And in those type of cases, there's a whole bunch of people that have opinions about stuff. And you need you might not just need 70 jurors, you might need 90. On things like aggravated robbery, there are very few people that are going to say like an aggravated robbery is something that they wonder is good, right? So it's more like, can you follow the law? What do you think about this particular issue? People don't tend to have strong opinions. Judge doesn't know that ahead of time. She doesn't have a crystal ball. She doesn't know which cases are going to work out or be dismissed. So no one's trying to waste your time. She just didn't know ahead of time. It is theoretically possible. So does that answer your question?
Yeah, I think so.
We can't actually predict the future, or I can't. All right, so let's talk about an aggravated robbery. I think we all know what a theft is, right?
Yes.
So an aggravated robbery is the theft with a special kind of assault that generally involves a weapon. Okay, so theft, special kind of assault, and weapon. I'm not going to talk about theft because if you don't know what theft is, there's other issues. I would like to talk about the special kind of assault. So the special kind of assault we normally deal with, and Marcus, I'm sorry, I'm standing behind here, is that someone is put in imminent bodily injury, fear of imminent bodily injury and death. I'd just like to know, can I have a volunteer? What type of things would make you in fear of imminent bodily injury or death? Juror number 13.
Having a gun pulled on you before they mention any sort of thing.
That's a good one. Let me ask you a follow-up question too, real quick. Does it matter whether I'm 3 feet away from you with your gun, or whether I'm, pardon me, 10 feet away from your gun? No, because your gun, I mean, it shoots, right? And no issue. I saw another volunteer. Juror number 7. All right. So that would actually be a burglary probably.
Now we assume.
Fair, fair. I saw, and so I'm talking just about a robbery here, that's a fair point, but different kind of fear. In fact, maybe your worst fear in some ways, drive me crazy. I'm sorry. Oh, all right, the gun.
Somebody with a gun, and, you know, very slightly intimidating.
Let's talk about a weapon different than a gun, because I think everyone understands a gun. Scary, big, by the way, they're always big, there's no small guns, just to let you know. Juror number 54, please stand up. Right, sword. If I had a sword and you're back there and I'm over here, just when I have the sword, is that an imminent fear of bodily injury or death for you? All right. Even with all these people in between us?
Yeah.
I guarantee you, you're the guy in the green shirt, he'd stand between you and me. It looks like he's rough. So my point to you is that, and it's up to you, this is your decision. But with a gun, I don't think the distance makes much of a difference, right? With some other weapons, I mean, if you've got a bat and you're 100 feet away, is there anyone here that thinks that's imminent bodily injury or death that you're fear of? What about 5 feet? I agree with that, right? So let's talk about that sword, juror 54. So I say, you know, I got a sword. I don't do anything else. I don't wave it. I don't threaten you. How does that compare if I'm saying I got this sword and I'm going to charge through juror number 25? I like green shirts, so that's why I mentioned it. I like green. I'm going to charge through juror number 25 and get to you. Does that make you more scared or less scared? So this isn't rocket science, but it's stuff we think about every day and y'all don't. And by the way, I know y'all get this, and you probably get it in a better way than us, but it's your first time appearing on an aggravated robbery case for most of y'all. So I'm trying to point out some of the different things for you to consider, right? What they're doing with the weapon, that makes some difference, right? A person that has it, I forget who said it over here, in a holster is a lot different than taking a gun out and pointing.
So where does intent come in?
Well, intent comes in is you have to take a look at those facts. And you as a juror have to make a decision about whether you think it was intentional. And, you know, it's one of those things that it's like, every case is different. And I can't, and the judge can't tell you whether they intended it. What I'm trying to do in my own poor way, and as quickly and respectfully as I can, point out different things you might want to consider in determining that intent, whether they were imminent bodily injury. And one of the factors that I'm encouraging you to consider, based on my 4 examples, is a person's words, what they're doing with the weapon, the type of weapon, right? And let's just be honest, which is more scary? You're all alone and you see a guy walking down the street with a bat, or you're in a group of 15, 20 people and you see a guy walking down the street with a bat. Being alone is always scary, right? I'm sorry, juror number 14.
But wouldn't it be different for everybody? What could scare you could not scare me, and I will be up to that. Not what you are.
So it's the law actually defines that. And it's not perfect definition, but it talks about what a reasonable person would be. Now, we could have good long-term discussions if any of us are really reasonable. But there are people that are scared of everything in the whole world. And it's the people that have a level of like confidence that I have never had. So I would say that what you're supposed to do is take those definitions and decide, was the person's fear reasonable, right? In other words, it's not the person way out here, the person way out there. It's the reasonable person using all 12 of these to end up with
Your Honor, I'm sorry, I'm gonna have to object to improper statement of the law.
All right, could you restate your question, Mr. Robinette?
I was trying to answer his question.
All
I'm
right.
sure I have one.
Okay.
My point to you is that you might want to consider in determining if it is imminent bodily injury or death, the fear of that, whether the person is alone that's being threatened or whether with other people. So the factors that, and we have 20 minutes, so I'll just try to make it quick, that I came up with that if you end up in this jury, I'm gonna be asking you to consider, I think that we've heard y'all list today, are the type of weapon, what was being said, what was happening with the weapon, down here just being held or being waved around or something else. I think I said the words of the person in the situation, whether you're alone or with others. The next issue that I have is it must be, and I say remember, there's a theft, an assault, and a weapon used in a particular way. Okay, theft, assault, weapon used in a particular way. That the weapon has to be in the manner of its use and intended use capable of causing death and serious bodily injury. I think we all agree, if you pointed a gun at someone that's capable of causing death or serious bodily injury, certainly gonna make it feel that, right? So I'm gonna suggest to you that maybe the same factors that we talked about with the imminent sort of play a factor in whether it's capable of causing death and serious bodily injury. If you're 100 feet away from someone, your chance, and you have like a 90% chance of causing serious bodily injury or death, pretty low, right? Can you throw a knife?
I could probably throw a knife on this.
All right. So if someone's getting ready to throw a knife, that's probably right, right?
Right.
And what if it is a kitchen knife? Yeah. I'm sorry.
All right, everyone. Excuse me. If we could make sure that one person speaks at a time, because remember, Brenna has to take everything down. And also, if you're going to be speaking, if you're not in the jury box and not on this row, you need to stand up. And if everyone could raise your card, and then whoever is speaking will address you.
It was jury number 26 that made the statement, and I'm sorry, sir, we refer to you by card numbers because I can't remember.
I can't see you. Stand up.
She wants you to stand up.
Okay, the thing is like, if you have patient doesn't matter how far you are, you know, you still can feel, you can run here, hit you. Because I was like driving before, you know, I know exactly. That's why.
I appreciate your perspective, sir. So what you have to decide as individual jurors, and I appreciate number 26 perspective, is does different distance to you make a difference in whether it's capable of causing death and serious bodily injury? I'm going over the factors because we don't know the facts. Neither me nor the prosecutors nor the judge can tell you what you're going to be taking into account. You don't know if it's a gun, a knife, a bat, a butter knife. You know, you don't know yet. We're trying to figure it out. If you can follow the law, and what you think about it. I don't know if the judge covered this. Judge, did you cover the right not to testify?
Yes.
Okay. My apologies. I'm trying to listen and write at the same time. I told you I'd respect your time. I think I'm almost out of time. If you end up on this jury, I look forward to seeing you. If not, I truly appreciate your time and I'll say.
All right. State, you have 20 minutes for specific, and defense, you have 20 minutes for specific. Does any of the jurors need a break before we continue? All right, so if one person goes, everyone must go. So what we will do is we will be back at 3:30. And everyone, please leave those cards, but when one person leaves the room, everyone must leave the room. All right, everyone, please rise.
Just leave your number on the chair, please.
Leave the numbers to the chair.
Oh, you'll have to wait and talk to me in the presence with the both sides. Thank you. Though.
No, sorry.
Don't worry about it.
We're going to take up.
Thank you.
Yeah, because there's. So once you get to the 6 meter fair in this case, and you have 20, that means that 12 jurors plus 6 equals 18 plus 20 equals 38. So the maximum for the cold strike range is about 38. So Yeah, folks are- So what happens is she has some projects where people said that they could be. There were about 5 people that said that. So what we'll do then is we'll get rid of those 5 that said they couldn't be fit. After. Yes, he does other rounds. We do it. So after we do it, then we sit down and we say, these are the left ones. And they get to get rid of 10, and we get to get rid of 10. Okay?
Okay. No problem. Sir.
Can you read back a bit?
No, I cannot.
Between the mask and that's.
Okay, can I just tell you, Brenda, I'm loving this 20 minutes, 20
I
minutes.
don't,
inside.
Judge.
I do.
That is punishment to the jury too, Judge.
No.
No, the worst punishment is listening to us longer.
Judge, I'd rather you just get rid of, I'd rather do it Angelini style, and we do our challenges in front of the jury.
Yeah.
than
See, see, Brenda, you, oh, could you put me on? So.
Mr. Vada, did you sign it?
Sign what?
Some documents in your email. Can you check if you have email? It should be coming from Norma Ferguson.
Hold on real quick. Let me get the deputy real quick.
Thank you.
Oh, you see the document, Julian?
Yes.
Okay. Just sign like you did before.
Okay. All right.
Okay. So you signed all the documents you were sent?
Yes, sir.
Okay, well then. Okay, we're in the main courtroom now with everybody else. Court should have the documents. Okay, we're invited to join room 1.
Joe Ray? All right. You ready, Brenda?
I'm ready.
Court is calling 2022 CR 1542, State of Texas versus Julian or Julian Vara. Can I have parties announced for the record for the state?
Joe Ray Garcia.
For the defense?
Barry Hitchings, attorney for the defendant, Julian Vara.
All right, and are you Mr. Vara?
Yes, ma'am.
We're proceeding, excuse me.
We'll call you off.
Laura, we're turning up.
Yes, Your Honor.
We're proceeding by video due to the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
None from the defense, Your Honor.
Mr. Vara, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor, I did.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Mr. Hitchens, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in the case and did you review it with your client?
I believe I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Vara, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Vara, I'm showing you what's entitled court admonishments, the defendant's waivers and affidavit of admonitions. Did you review that document? Excuse me. I'm gonna need you all to quiet down a little bit. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand your charge of burglary of a habitation force? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement, it gives you more than you bargained for. The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is, Your Honor.
Mr. Varro, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. There's a $1,500 fine. There are no applications. There's to be no contact with Jeanette Rice, Diana Guerrera, Tilson Holmes. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defenses of the plea bargain agreement?
It is, Mr. Garcia is going to read some additional material on the plea bargain agreement into the record, Your Honor.
Mr. Garcia?
Yes, Your Honor, and I apologize. There's a handful of cases we're taking into consideration that aren't on the plea page.
Yes.
The first one is 2022 CR 1471. The next one is 2022 CR 1541. There are two JN numbers. The first one is 2048333. The next one is 2048334. And county court number 670102.
All right, is that the entirety of the plea bargain agreement, Mr. Hitchens?
I just want to make sure on the first one is 2022-CR-1541.
Yes.
Okay, that was one I wasn't sure. That is our understanding of the plea agreement, Your Honor.
Mr. Varro, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
It is, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not, Your Honor.
Then, Mr. Vera, to the offense is charged in indictment. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes.
State offers State Exhibit 1 and its attachments.
Any
No
objection?
objections, Your Honor.
Mr. Varro, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
All right, then the court will follow your agreement, sentence you to 8 years in prison. There's a $1,500 fine, time and money to run concurrent. There's to be no contact with Jeanette Rice, Diana Guerrera, Guerara, Tilson, Tilson, Holmes, Homes, Take in consideration the following cause numbers: 2022 CR 1471, 2022 CR 1541, JN numbers 2048334, 2048333, County Court Cause number 670102. Is there anything else from either side with regards to sentencing?
Nothing from state.
Nothing from the defense, Your Honor.
Mr. Guerra, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, Mr. Vera, good luck to you. We can go off the record. Mr. Vera, you need to do better with your life. Otherwise, you're going to find yourself in and out of prison, okay?
Yes, Your Honor.
All right, good luck. If there's a drug problem going on with you or mental health issues, there are free places in San Antonio, okay?
Yes, ma'am.
All right, thank you. Thank you, Mr. Hitchens.
Thank you, Your Honor. May we both be excused.
Yes,
Thank you, Your Honor.
you're welcome. Norma Vera, 14, I can go back.
I sent you a chat.
Yes, you may be excused, Rebecca. Thank you so much.
Thank you. I'll see you tomorrow.
All right, bye-bye. Mr. Broderick,
Your Honor,
so tomorrow you will be available by 2:30?
I really think I'll be available by 2. It starts at 11:30. If David Pritchard meets with me longer than 2 hours, I'm going to be really, really surprised. I would like to be early, but I'm less concerned about staying late.
All right, so I'm going to tell the jury, instruct the jury to be here tomorrow by 2.
That's good.
All
I
right,
appreciate it.
you're welcome. So state will start with testimony tomorrow at 2.
Thank you, Judge.
You're welcome. All right, All right, everyone, please be seated. So, ladies and gentlemen, as I said before, there are a lot of things that are still happening in this court, even while we're doing jury trial. So when you came in, I was involved in another hearing that was unrelated to this case. So next time when you all are outside, even though we give you a specific time, if you can just line up and the deputy will come and get you when it's time for you to come in. All right, so I'm going to turn it back over to the state. State, you may begin.
Picking up where I left off. Picking up where I left off, the burden's on us to prove the case. We have to prove the elements to you. That's all that we have to prove. We don't have to prove anything additional. So if you have a question about something, it doesn't go to one of the elements, not to say that it doesn't matter, but legally it doesn't matter. So you have to disregard it as far as whether or not we proved our case. And Judge covered this, the burden of proof. The burden is ours. We probably accept it. We have to prove our case to you beyond or without. Like she said, there's no legal definition, but I can tell you what the courts have said, that it's not 100%. It's not removing all doubt. It's not beyond all possible doubt or beyond a shadow of doubt. It's sort of up to you to determine what beyond a reasonable doubt is to you. It's used in every jurisdiction across the U.S. for traffic tickets and murders. Types of evidence that you can expect to see. Live testimony, that's from a witness who takes a witness stand, they take an oath, they swear to tell the truth. Some witnesses you may see, a victim, police officers, eyewitnesses. Other types of evidence you can expect, photos, videos, and other physical evidence. If it's a robbery, maybe a gun or a knife, fingerprints, things like that. So this is a question that I always ask, and I always have. I had a partner once who was like, I don't want to be robbed anywhere. It's like, would you rather be robbed here or here? But there's a purpose in it. Who would rather be robbed here at a San Antonio's first game? Most people, right? Juror number 11, why would you rather be robbed at his first game?
There's more people around.
More people around. Anyone else? Juror number 54?
Less likely to be killed.
Less likely to be killed. Juror number 32? Cameras. Juror number 1?
I think they're less likely to get away with it and more eyewitnesses.
Yeah. Less likely to get away with it, more eyewitnesses, 57.
Yeah, just the amount of people there.
Yeah, amount of people. Now,
Safety in the crowd.
Say that again?
Safety in the crowd.
Safety in the crowd. Now, let's say that we had this case where someone was robbed at a Spurs game. I guess who would expect us to call every single fan that was in the stands who witnesses? Who here thinks that we need to call every witness? Every fan who was in the stands to say that was a person. Who would rather be robbed here? Okay, just making sure. And so let's talk about this. One witness rule is something that we cover. And the example that I give is that, let's say you're walking in the alley, someone comes and robs you. You know who the person is. You go to the police station. You say, "This person robbed me. They're Joe Smith." The officer's like, "Oh, was there anyone else there?" You're like, "No." Were there any cameras and photos taken? No. Any fingerprints? No. But I know it was Joe Smith. Sorry, that's not it. So the law says that because one witness is enough, the law says that one witness is enough. If that one witness proves all the elements to you beyond a reasonable doubt, and you believe that witness. So my question for you is, if we were to only call one witness to testify, you believe that witness, and you believe that they proved all the elements to you beyond a reasonable doubt, who here would still need more to find someone guilty? And so, one, I strongly agree that you would need more than just one witness to find someone guilty, given my example and given the judge's example earlier. So, one, if you strongly agree with that, move forward. Juror number 8, 10, 14, 19, 24, 26, 36, 30, 32, 37, 40, 41, 47, question for all of you, just raise your card on that. I understand that you would like to see more, everyone always wants more evidence, right? But my question is, would you hold it against us? Would you raise our burden and make us bring more than one witness, even if, and it's sort of hard because it's hypothetical and you have to assume certain things, but I'm saying you assume that that witness, you believe everything that they're saying as far as the elements, and you believe it beyond a reasonable doubt. So every one of you who raise your cards, even if we do that, and you believe that witness, you believe that they prove all the elements, you're still saying you're gonna need more, you're gonna make us prove more to you than that. So the numbers were number 8.
It does depend on how that correlates with the other facts and evidence.
And so-
But eyewitness reliability is a serious question. It's only one, and you don't put any other facts in the evidence. I would have.
Okay, but remember, we're assuming that you believe that witness. You have
I'm
no
not
doubt
saying
about
they're
what
not
they're saying.
credible. They're fully credible, but it's gonna depend on, was it dark? How long they see them? Did they have the stress of focusing on the weapon?
Again, but.
So even if I find it credible, yes, if all you got is their testimony, that
I
would
don't
be a problem.
Okay, but not only do you find them credible, but you have no doubts about what they're saying. So if I say it was juror number 4, and you believe that, believe me saying that, and you believe that I've proven all the evidence. So you don't have these additional doubts as far as that you're adding as far as the darkness and that you believe that you proved or that I proved all the elements to you beyond a reasonable doubt.
And what I'm saying is, even though I believe that's what you believe,
Okay,
I have a problem.
okay, you're saying, so you don't think that I'm lying, you just have doubts as to. Juror number 1, raise your card.
Yeah, so I was confused at first. I thought you were saying that. Strongly agree, you're saying that you would just provide the witness. but
Yes.
You would just need to provide evidence. So are you saying that you have provided the evidence in space by them?
So that one witness who testifies is evidence. So they're taking stand, they're swearing to tell the truth. So that's evidence that you consider, just like a photo, a video, a confession, all of that is evidence. And it's up to you to weigh how credible you are.
And that's the only evidence you report that.
Hypothetically, yes, if there was only one witness as evidence.
Only one witness and no other evidence. But I'm saying.
Yes, because the witness is evidence.
Is the only evidence.
Yes.
Yeah. But, transportation, no.
Okay, and so even if you believe that witness, you're still gonna need more, far more witness.
All right, just a second. Let me pause you for a moment.
Yes, sir.
Everyone, this is the one witness rule. Because I'm hearing people adding things to the hypothetical. This is the hypothetical. A witness testifies. Who knows? It may be the president of the United States. It may be a nun. It may be Pepe Longstocking. It could be anybody, but it's just one witness. That witness is sworn in. They're sworn to tell the truth. You listen to the witness. You believe everything that the witness is saying. So there's no issue where you're saying, well, was it dark outside? That's not in the hypothetical. The hypothetical is a witness comes in, not for this case, it's a hypothetical, any case, they're sworn in. You listen to everything that they're saying. You don't have an issue with their credibility. You don't have an issue with whether it was dark or not dark. You're listening to them, you believe it. What they're saying proves every element that the state has to prove beyond a reasonable doubt. Based upon that, would you still say, yeah, I want more? Does everyone understand the hypothetical?
Yes.
So when people add to the hypothetical saying, well, was it dark at night? Were lights coming? Were they blinded by light? That's not in the hypothetical. The only thing that's in the hypothetical is one witness comes in, sworn to tell the truth. You listen to them. They prove every element of the state's case and you believe their testimony. Does everybody understand? That's the hypothetical.
Yes.
All right, Mr. Sanders, I'm resuming your time.
Thank you. So with that being said, raise your card if you still need more. Tier number 8, 10, and 14. So defenses. Can't really talk about the facts. I don't know what defenses may potentially come up. I just have to cover in general defenses that I think could potentially come up to see how you feel about them. And to tell you the law on it. So self-defense could potentially come up. Person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. The way I like to break it down is think of it like a chair. There's 4 parts to it. Reasonably, immediately necessary, and unlawful use of force. So the example that I was doing with number 6, where I take his hat and he tries to take it back from me and I touch him. Can I claim self-defense? Does he have a right to take his property back?
Yes.
Was my actions unlawful? Voluntary intoxication, I don't know if that would come up in this case, but it's not a defense to a crime. You can't say I was drunk, I was high, or whatever. I'm now involuntary, that could be a defense, but I don't think it would be an issue. Why is it important that we prosecute individuals for theft and robbery? I guess, is there anyone who thinks that is not important? Does anyone feel that some robbery cases shouldn't be prosecuted? And we sort of talked about this when the value and other things. But other than like the value, is there anything else where they're like, I don't think that should be a criminal case? For example, if there's only a threat, no one's injured. Does everyone feel that robbery and theft, they should be crimes?
Yes.
And that we should prosecute?
Yes.
Have you, a close friend or family member, ever been arrested, charged, or convicted of theft, or robbery, or a similar offense? You can raise your card if that applies to you. Your number 13, 12, 14, 16, 19, 53, and 56, and 64. So all of you who raise 13, 12, all of you who raise your cards, I guess my question is there anything about either your experience or your family member's experience that will affect your ability to be fair and impartial in this case, knowing that it's an aggravated robbery case? Raise your card if you think it will affect you. You're number 19. Are you comfortable talking about it in front of everyone? Okay, we can talk later. 13. Do you know someone you believe has been treated unfairly by the criminal justice system? That applies to you. Raise your card. Have you or someone you know had a negative experience with law enforcement that you think would affect your ability to be fair and impartial in this case? Anyone? And judge covered this, but I want to make sure we didn't miss anyone. Anyone uncomfortable sitting in judgment on another person because of religious, moral, or philosophical beliefs? Number 21 and what? 46. Okay, just talked about punishment, and must be able to consider the full range of punishment. First degree is 5 to 99. Certain circumstances, it could be bumped up to 15 to 99. Can everyone here consider the full range of punishment?
Yes.
Is there anything else that I didn't ask that you think we should have? Thank you.
Good afternoon, Ken. Again, I'm going to promise to be as fast as possible. This is generally specific for Dyer, so I'm going to go and ask some specific questions of folks. Since I've got 20 minutes, I'm going to start at this end, more likely at this end, less likely at that end, and then I'll finish up. I had some questions for, I think it was juror number 7. Sir, you're Mr. Briscoe, is that right? So my question just was when we were talking about robbery, you expressed something about like someone coming to the house. Someone says something like that, you just wonder if there was a strong feeling you had, an experience that might be weighing on your mind. If you're uncomfortable talking about it, like in front of everyone else, that's fine. Just ask you about it because if it would affect you, we wouldn't want you to sit on this case. So that's good. I'm sorry, say the last part. I just said the last part. So understanding that that's a different type of case, right? A robbery, although they both involve violence or the potential for violence. And you've got to, this is one of those, you're either pregnant or you're not pregnant type of questions. Is it that experience going to affect your judgment in this case? And I would say, I mean, everyone wants to be fair, right? Everyone always says that. But is it going to be in your mind so you find yourself leaning towards conviction, or I guess unlikely not leaning towards conviction?
No, because I know the law and what, you know, rights you have. Some law. Only my experience. So we have had it, I think, forces right now.
Didn't know how big the experience was. My house is people can use it. It sucks. Had to buy new TV. See, I was going to ask jury number 10 some questions, but I think that their questions took care of it. So thank you for your time. Juror number 20, I'm seeing on your juror information card. Yes, we actually read these sometimes. That some of your relatives are law enforcement officers. Do you mind telling me who those relatives are? Is it like a second cousin? Is it a brother?
I've got 2 uncles.
Right. So I don't anticipate when I say, you know, some cases are like law, they're beating up a law enforcement officer. Okay, on that one, you have stronger feelings. But if you find yourself, because the police officers come in and say, hey, we think this happened. If you find yourself trusting the police officer more and their opinion being honest, then you generally can't sit in the case. In other words, if you're going to give their word more credence because they're a police officer, you're the only one that knows that. I'd ask you just honestly, because I was close to one of my uncles and named my kid after him, and real close to the other. And if they came in, based on the profession, they're accountants. So I don't know how that really affects the criminal case. But I mean, I trust them more. And if someone was an accountant, I tend to like an accountant. Is that going to be affecting you in this case? Or you're leaning toward believing what the police officer says more than others because of your experience with your
That would, it's kind of hard to say, but my experience with police officers, including my uncles, has always been very trustworthy.
Okay. So this is one of those things that you have to tell us one way or another. Only you know yourself, right? If a police officer would come in and someone else would come in, and identical twins, but one's a police officer and the other isn't, they gave the testimony, and would you believe the police officer a little more, identical twin, same testimony, because they're a police officer, or would it be the same? That's what my question.
That's difficult. I guess I would have to say police officers from a credibility standpoint.
Thank you. And I'm skipping over some of y'all because like you already answered the question, so it's not meant as a personal front, just to move on down. Issue number 26, Mr. Lang, is that stuff? And would you mind standing up because the court is in trouble? So I get, you had answered earlier that you have a little bit of trouble with English language, unless we have one.
Not that much trouble, a little bit, because sometimes like I would rather use logically than some like 3 sentences, you know what I mean, 3 words. That's the thing, yeah.
So here's the way to put it. I have a stepmother, and English was not her first language. But when you talk with her, even though she has an accent, she doesn't miss much. In fact, sometimes she misses less than me. Then there's other people that have a little bit of a language barrier, and like, you know, they just feel uncomfortable because they're concerned they might miss something. I don't know you, and I'm certainly not trying to embarrass you, but it isn't weigh on your mind. Are you concerned that it might?
I'm not that concerned that much, but it's just some accuracy. They're a little bit accurate sometimes, like for example, I mean this time is 37 years. But sometimes when I talk to my son, sometimes I have a little bit problem on that, a little bit, but not that much. Over like 90%, that should be okay. But some of them, you have to read over there when you ask a question, I have to read over there to answer that. That's why. Yeah.
So there's a little bit of a language barrier.
I don't think it's like just very little, you know what I mean? But it's not as good as my first language, that's for sure. But
do you mind me asking what that was? what your first language was?
Chinese, yeah.
Well, certainly your Chinese is better than my English, and I'm sure your English is better than my English. Thank you very much. Juror number 27, I think you had said something earlier about, Your Honor, would you remind me about what issue juror number 27 had spoken about, that you had heard some issues about?
That is so funny that you would come to me for that. Of course I will.
You're smarter than me and your memory is better.
Let me go to my handy notes.
Oh,
has the state already informed you?
yes, but evidently everyone's memory is better.
Okay, great.
Sir, so in a criminal, so the issue was juror number 27. Are you able to stand up? Do you mind? Yeah. Okay. So Mr. Is it Aiken? Aiken, Mr. Aiken. So the law in a criminal case is that the juror doesn't have to testify. And there's a lot of reasons why someone wouldn't want to testify. Sometimes they're have a terrible past. Sometimes they're guilty. Sometimes they're nervous. Sometimes, I'll guarantee you, he's pretty good. And the prosecutor is pretty experienced. And the person getting on the stand is not. And so they're a little concerned about, like, how am I going to look with this experienced prosecutor, maybe experienced defense attorney. The question to you is, the law says that you're supposed to take the fact that the defendant might not testify. In this case, it's Mr. Contreras. And if he doesn't testify, you're just supposed to throw it out. You're not supposed to talk about it. It's not supposed to be in the law. That's the law.
Hypothetically.
Not hypothetically. Like,
Well,
if he doesn't, you're supposed to not talk about it. It's not supposed to win the law. Now, I've had people many times that say, you know, Eddie, I understand that's law, and this is not a problem, by the way. If you feel this way, we just want you to tell us. But even though it's the law, yeah, I'm going to hold it against him because that's the way I am. You know, I would want to get on there. And if someone doesn't
Beside me, that's where I'm.
Okay, so you're saying you would hold it against them if they didn't testify?
Yeah, I would.
Okay. Thank you.
You're not guilty. You're not guilty. Say it.
I get it. Thank you very much. You know, I think that's all the individual questions I have for folks. 2 follow-up points, and then we're gonna let you out in the hall for a little bit, maybe call some of y'all later. So there's some things that may happen if you're sitting on a jury. Number one is, let's say that someone commits a theft, but they didn't assault anyone, and they certainly didn't use a deadly weapon. You may get an instruction that says, if you don't believe they committed the aggravated robbery or robbery, but they committed the theft, you're supposed to, if you believe that, then you're supposed to find not guilty of the aggravated robbery. Not guilty of the aggravated, not guilty of the robbery, and guilty of the theft. It's called a lesser included. So there's 3 things here, right? There's the theft, and assault, and then the weapon. So if you don't believe beyond a reasonable doubt of the weapon, then there's lesser included offenses that you can consider. I'm letting you know that because I guess some people are like, well, I don't want to consider a lesser included offense, even though it's the law. Is there anyone that for them it's either aggravated robbery or that's it? Had someone say this before? Is there anyone that feels that? Appreciate your time. Look forward to seeing you on the jury in front. Thank you.
All right, everyone, thank you very much. Juror number 3, if you could remain, and if I could have everyone else step in the hallway, and we're going to call you back in. People who are in the box and you're leaving, please take your personal items with you. And everyone, please leave the expensive cards behind. All right, everyone, please rise for the jurors. the jurors that will be on, if you could check and make sure that they are correct. Number 2, number 3, 11, 13, 16, 18, 22, 23, 28, 32, 33, and 35. Any objections to those as making up the jury panel? State.
Just a quick second, I was trying to write it in 2 places, but I believe that to be accurate.
Judge, I'm sorry, I lost, I was trying to write as fast as possible, 20, 22, 23.
2, 3, 11, 13, 16, 18, 22, 23, 28, 32, 33, and 35.
Judge number 23, I believe is the woman who her mom is in the transplant thing. I think we agreed to strike 23.
That is correct.
Where's the one for the difference? And where's the one that I gave calls? All right, everyone, we're not ready.
No,
Judge, I'm sorry.
she's figuring it out.
Oh, okay.
All right, we're gonna go back on the record. These are the jurors: 2, 3, 11, 13, 16, 18, 22, 28, 32, 33, 35, and 36. Any objections? State.
No, Judge.
Defense.
No, Your Honor.
The alternates are 45 and 48. Any objections?
Not from the defense. Your Honor.
All right, let's bring the jurors back in.
You have to sit back. We're not anywhere. Anywhere.
No, you can anywhere. You need an excuse.
No, anywhere you like. It just needs to be one.
Click on the bench and if you need an excuse for work, all you gotta do is create your name.
Anywhere. Not everybody will get a chair, so there's something to be standing. 14 people.
If you need to get down to the parking, you go down to the basement.
All right, everyone, please be seated.
Come on in, have a seat, find space. You don't have space, it's all the way to the front. Okay. Right there.
Yeah.
Move forward, move forward. There's no one chairs. Move forward, just right here. You don't have to come in.
All right, everyone. Thank you so much for your service. Of course, we cannot have jury trials if we don't have jurors. And I know sometimes people say, you know, it takes a long time and it takes a lot out of their day. But I always tell people, your country only asks really so few things for you. They don't ask you to vote. You can vote or not vote. They don't have the draft anymore. I've had plenty of relatives who served in the military. They didn't wait to be drafted, they just went. I had an uncle who served in the war, and he went when he was underage because he knew he was going to be drafted because they were drafting all of the men in Grand Canyon, Louisiana. So your country only asks that you serve on a jury trial when you're called up to serve. So we appreciate you for attending. The people that I call, I'm going to ask that you take a seat in the jury box because you will be the persons who will be on this jury. Linda Monell. Juror number 2. Sylvia Flores. Taylor West. Luis Calderon. Shaquille Blacksher. You can sit anywhere in the box you want to. Brenda Estrada. Amelia Brackman. Daniel Martinez. Jessica Anton. Ryan Gutierrez. Carlos Mendoza. Paul King. John Jacobs. Ricardo Castillo. All right, to everyone else, let this marinate, don't rush to the door. If you want to, you can be sent back downstairs to be placed on another panel. Or someone's already shaking their head. I said, let it marinate. Now, what I can tell you is that you do receive payment for your services here today. Of course, it's not a lot, but it's something that would probably pay for a lunch or a dinner if you're not too expensive with your dinner. Or either you can take that money and you can donate it. They have different organizations downstairs that you can say that you would like your check to go to a specific organization. And there are a lot of good organizations that you can donate it to if you so choose. Otherwise, maybe in 2-3 months, a check is going to come in the mail for you. You're going to be surprised and say, wow, this is great. And then you can do whatever you wish to do with it. For those of you who wanted your parking taken care of, you'll need to go back downstairs to the jury room. And I hope that you all had an interesting and informative time being here for jury selection. I hope that you all make sure that you continue to answer the call when you're called for jury selection, because it is greatly appreciated. So be sure to take your sheets with you. And if there's an issue with your work, or if someone doesn't believe you were here, just let us know. All right, thank you all for coming. State and defense, if you want to switch your chairs around. All right, to the ladies and gentlemen in the box, I want to give you our instructions so that you'll know where to go and what you're to do tomorrow, okay? So I want to remind everyone, if you ever need a break, just raise your hand. I'll have difficulty seeing you because I have this computer screen that's blocking my way. But I guarantee you, Brenna, who I think has eyes in the back of her head, she'll see you, or either the state, the defense, or either one of the deputies will see you and they'll let me know. Don't ever be afraid to raise your hand and think it's an inconvenience. Just raise your hand and we can give you a break whenever you need it. The other thing, you are allowed to, if you want to bring coffee or bring drinks, that's fine to bring that. We want you to be comfortable, but make sure it has a top on it or something so it doesn't spill. I have no control over the thermostat in this courtroom. That's just there, I think, for decoration. So usually of late, it's been extremely hot in this courtroom. That's why you'll see me sometime unzip the robe a little bit, because it's extremely hot and it's like 100 degrees for me. But then sometimes it's ice cold in here. And when I say ice cold, I mean 55 degrees maybe. So it's best that you bring a jacket or something because it's easier to take off. And I'd rather for you to have that than not have it. We're going to start tomorrow at 2 p.m. So that'll give you a break throughout the day, and you can let your employers know or whomever it is that you're in jury trial, but you'll have the morning free. We're starting in the afternoon because I have other cases on the docket that I have to take care in the morning. And again, when you see people coming through the door for me, sometimes you may see deputies coming through that door. It's for cases not involving this case. So I want to make sure that you concentrate on what's being presented by the state and potentially the defense and the questions that they're asking. If for any reason you can't hear a witness, you need to let them know, because I know the state and the defense both want you to be able to hear the witness and hear the questions that they're asking. Sometimes the acoustics are not great. Both the state and the defense will have microphones, but if you can't hear their question or hear the answer, be sure to let them know, okay? Does anyone have any questions? Yes.
Oh, listen. Okay, you said tomorrow would be at 2.
Yes.
If it goes, say, to Thursday or Friday, would it be the same time, or does that change?
Oh, that's changed. The reason why we're starting tomorrow at 2 is because of the docket that I have. So I still have probably about 60 or 70 cases that will be going on in the morning, even though we have this trial in the afternoon. So tomorrow is one of our busy days. So that's why we'll be starting late tomorrow. Okay. What I can tell you though is that I like for us to recess by 4:30 each day. Tomorrow we'll probably be later here than 4:30, right? But normally we'll recess at 4:30. That way you can beat rush hour traffic. And if someone has children or something they need to pick up, you'll be able to do that. Now, the only exception to that, sometimes if we're in the middle of a witness testimony, we may end up going over the 4:30 time, but I like to try to get you out of here to avoid rush hour and traffic. Okay. Any other questions from anyone else? All right. When you report tomorrow, you're not going to come to inside the courtroom. You're going to come to the jury room. Deputy Laura is going to show you where that jury room is. Feel free to bring whatever foods you want to bring. We do have a refrigerator with some food in it. But be sure to bring whatever you want to bring, and you can place it in the refrigerator. And of course, we'll give you breaks when needed. The other thing, most important thing, we cannot start unless everybody is here. So if we're missing a juror, we won't be able to start till that juror gets here. So remember what time we're going to be here tomorrow? 2 p.m. And because I'm doing my docket in the morning, I'll be able to immediately start with you all at 2. And what's going to happen tomorrow is when you come in, I know you've already done the oath downstairs, but I'm going to swear you to an oath that's specific to this case. And then after that, we'll start with our testimony in the trial. Okay. All right, everyone. Thank you so much. We'll see you tomorrow then at 2 p.m. But everyone, please rise for the jurors. Hello. Yes, could you, yes, it is. Could you give me 5 minutes, please? Yes. All right, so before you take him back real quickly, is there anything else from either side? All right, then I'll see you all tomorrow. If there is some issue, then let me know and we'll take it up before then.